The broadcast is now starting. All attendees are in listen-only mode.
Hello and good morning, good afternoon, good evening for those of you joining us around the globe. My name is Preston Bucati, and today we're here to talk about the implications of the recent Schrems II ruling from the CJEU. So with me on today's call, I've got Camilla Winlow, Director of Consulting Services at DQM. And like I just said, we're going to talk today about the practical implications of the recent Schrems II case out of the EU and what it means for data transfers between the EU and US. So I appreciate those of you that have joined already. We'll maybe just give it one more minute or two, especially in today's day and age with all of us working remotely. I know there's sometimes a tendency to have back-to-back calls, so we'll give folks a chance to maybe use the restroom or grab that extra cup of coffee before we dive in and talk in more detail about EU and US data transfers, the practical implications of Schrems II. So perhaps as a bit of an introduction, I'll go ahead and at least introduce myself. My name is Preston Bucati, and those of you on the call may know me by now, having done several webinars on this topic as privacy law continues to evolve. It's an exciting space, but my background is in law, and although I like to think I have now joined the light side of the force, I still get a lot of pleasure teaching folks about legal repercussions, learning about these laws, and dissecting them to create some practical, actionable guidance for organizations. And through that activity, obviously working in all kinds of spaces, not only as it regards laws like the GDPR or the California Consumer Privacy Act, which some of you may be familiar with if you're in the States, but also the respective privacy and risk management frameworks that industry is putting together to try to meet these legal regulations, like ISO 27001 or the more new standard 27701. Now, with me on today's call, I've got Camilla Winlow, the Director of Consulting Services. Camilla, would you like to introduce yourself to those that have joined us on the call here?
Sure. So, unlike Preston, I am not a lawyer. I am an implementation consultant. So, I am particularly interested in privacy by design and all of the practical side of privacy. So, how do you build that then? That's me. I lead our privacy implementation consultancy. And I found myself doing this, having actually been part of 3 leadership teams launching new businesses that were particularly created in response to regulatory change. So that's what I like, turning regulations into things you can do that are business beneficial. And as you can see, I have a bunch of different qualifications. And I've also won awards for privacy by design training as well. And I'm actually responsible for our new privacy by design qualifications. So that's me.
Awesome, thank you, Camilla. And for those of you on the call, part of the reason that we've got Camilla to join us is, again, we're talking about the interrelation between the EU and US. So I thought it would be interesting to hear that perspective from across the pond and get kind of the both sides of the coin as it relates to this recent court case. So before we dive in too much, a brief word from our sponsor, right? GRC International has got years of experience in this space. And so I work for IT Governance as a consultant, but we've got a group that's dedicated to privacy and cybersecurity risk issues. And so regardless of the issue you may face, or increasingly important, where you may be in the world, as we all sort of spread around globally and virtually, this topic has become more important and presumably will be more important as this pandemic continues and working from home or virtual working gets increasingly normalized. So again, a bit about IT governance. We're a leading provider of cyber risk and privacy management solutions, from bespoke consultancy services all the way up to do-it-yourself toolkits and resources that are available on our website online. DQM is quite similar, but Camilla, I don't want to step on your toes at all. Do you perhaps want to say a word before we dive into our agenda?
Sure, yeah. So we're nearly 25 years old. It's going to be our 25th anniversary next year, which is pretty old for a data protection consultancy, actually. But data protection is part of one of our sort of arrows in our quiver, if you like. We're all about harnessing value in data assets. So we're about building confidence in data, building confidence in your ability to use data for decision making, and building confidence in your ability to use data to build organizational value as well. That's us. We're practical, hands-on people.
Awesome, awesome, thank you. So today's discussion, like I said, at a high level, we'll be looking at this recent court ruling, right? The Schrems II ruling that some of you may be familiar with. But perhaps more importantly is the back end of our presentation, where we'll really start to talk about where the rubber meets the road, right? What are the implications for data transfers between these two regions? And as a result of this court case, what are our new options and alternatives to still effectuating data transfers, but doing so compliantly according to the rule of law in various countries, and in light of a very shifting regulatory framework, as we'll discuss in more detail, depending on some of the current administration here in the US, what the future might bring is going to be certainly quite interesting. So we'll talk about this in more detail, and as always, if you have questions over the course of this presentation, don't hesitate to shoot them in on our chat feature or over to our service center, and we'll do our best to address those kind of at the end of this call. Or of course, if the questions are long and complicated, we're always happy to reach out to you directly as well and kind of answer those questions. So let's go ahead and get started, right? Why are we here today talking about some guy in Austria? Well, it's ultimately about data. Data, right? As technology has increased over the past 20 years, in fact, quite recently, I listened to an interesting podcast saying that perhaps Moore's law has been invalidated and now we have to think of a new paradigm. But technology is constantly increasing, and that means data collection, data processing, the business utility of data has increased as well. And so over that time, you see this timeline, we've got regulatory responses to this societal issue, right? Just like anything ever in the history of human society, people invent a new technology, it gets used by the wider public. Through that beta testing, we figure out sort of our problems, our pros and our cons, and then the government responds. And so as early as 1995, right? I feel old just saying that, but as early as 1995, we've had laws in place dealing with privacy and the protection of personal information. And so you see over that timeline that from 1995 even up into the early 2000s, this was already a well-established legal paradigm, at least for those of you in the EU. Now, those of us in the US, it's a bit more of a complicated history because our privacy laws are really dictated by industry, by sector, and by data. We don't quite have a comprehensive framework approach to this topic. And so you see in 2000, the EU and the US agreed on a concept called safe harbor. The idea was increasingly that, hey, our privacy laws in the EU and the US are slightly different, and that's fine, but we need to find a way to transfer data between those two regions effectively for business purposes, but also compliantly for legal protections, right? So that people, regardless of whether they're American citizens or EU residents, would have a similar level of privacy protection regardless of where their data is collected, processed, stored, and used. And so you can see there, as early as 2000, people started expressing concerns. Now in 2004, those concerns elevated all the way up to a regulatory body, and so that's when we start to see some formal pushback from the European Commission. This idea that, is data in the United States really subject to a safe harbor? Is it really protected in the same way that we think it would be here in the EU? So again, in the early 2000s, you already had some people starting to raise their eyebrows and question the effectiveness of this data transfer mechanism. Well, that all got blown up quite spectacularly in 2013 when Edward Snowden released information detailing just how widespread and pervasive government surveillance from the NSA, CIA, FBI, and others through their prison program, that really shone a light on just how much interception, permutation, and access that the US government has to people's personal information if it's processed, stored, or transmitted through the United States. So after those revelations in 2013, that led to the ultimate invalidation of safe harbor. Took 15 years, but it eventually got done. Now, here is where the timeline started to pick up, right? I just told you Moore's laws may be out of the way and we have to think about a new paradigm. Well, technology continues to increase at a rapid pace, right? Today, the buzzwords of the day are blockchain and AI and algorithms. There's all kinds of sexy stuff that we can do with cloud computing, but that also means that we can collect, process, and store vastly more information. And so as a result of that technological growth, the European group put together the General Data Protection Regulation in order to provide legal protections for this data over in the EU. And in 2016, the EU and US agreed on a privacy shield framework to essentially replace the safe harbor. Now, Camilla, if I can pass the baton to you briefly, you maybe feel like you could fill us in on what started to happen in 2016 with this Austrian advocate, Max Schrems.
Well, Schrems, actually, he was instrumental in safe harbor failing in the first place. So that was the first Schrems case. So Schrems II, in short, the piece to add to this is when safe harbor failed, what the European Data Protection Board asked for was they asked for the European Commission to fix the failings in safe harbor. And that was the intention of Privacy Shield. But the failings in safe harbor were to do with US state surveillance. So a big difference between what's lawful in the EU and what's lawful in the US is in the US, you are comfortable using mass state surveillance technologies, partly because you feel like you're responsible for the world's security. In the EU, because of, well, our history with the Nazi Party and war and various other different repressive regimes that we've had across the EU, you cannot do that. Governments cannot do that. Mass state surveillance is out. So this has always been a problem. So when Privacy Shield came in, the European Commission was only given about 3 months to sort it out. It's pretty short to try and change something quite so fundamental. And within weeks, there were already concerns being addressed that what they'd agreed with Privacy Shield couldn't succeed. It couldn't do the things that were being asked of it. It was more robust than Safe Harbor, but not robust enough. And so Max Schrems pretty much immediately started Schrems II, the new case, saying you can't use Privacy Shield either. And that's what's continued on. So in 2016, we had 2 more cases which are listed here that reaffirmed this point that you can't have mass state surveillance of EU citizens, full stop, by anybody, by a domestic government, by a foreign government. No one can do that. And almost from the moment that Privacy Shield was launched, it was doomed. And so again, it took 15 years to kill Safe Harbor. Privacy Shield fell in 4. And so now we find ourselves in a position where this time around, where CJEU had previously said that with the right extra mechanisms, you could replace Safe Harbor with something that broke the failings. This time they've said that you can't. And so what we're looking at this time is a requirement on the US to change its state surveillance approach in order to rectify and remedy the problems that we had with Privacy Shield. So the EU and US are talking now about what that might look like, but whether it's actually something practical, that's another matter. Shall I hand back to you, Preston? Is there anything else you'd like me to talk about there?
No, thank you, Camilla. The only thing I would add is keep in mind, folks, that over the course of that time, the GDPR was already kind of written and not quite set in stone, but was on a timeline to be implemented. And so you see that on the top of this timeline, that over the course of these cases that are questioning the validity of some of these transfer mechanisms, we still have this law that's taking effect. And so what we have is a sort of weird situation where we're telling people they have to transfer data according to certain valid mechanisms, while at the same time, some of those mechanisms are under review, perhaps being invalidated, and that's ultimately kind of led us to where we are today in 2020.
Yeah.
And so as a brief refresher for folks, just a reminder, right? GDPR, it came into law in 2018, and it's an expansive, all-encompassing law in the EU. It's a regulation, as a matter of fact, so it applies across the EU. But it gives privacy rights to individuals, and it requires organizations to take a risk-based approach to data protection. Stress that last point again, just because I'll think often in my experience, and Camilla, I'll let you chime in, but in my experience working with American organizations, it's sort of a wholly different understanding.
Oh, Preston seems to have frozen. So I'll chime in while we wait for him to reconnect properly for us.
Relation from the EU.
You're back. Preston, we lost you just as you were explaining the approach that the US has.
I'm sorry. So my point ultimately was that in the United States, I think we're a little bit more used to an approach to law that says, here's what you can and here's what you cannot do. And if you don't do it, we're going to come chase you down and find you. Whereas in the EU, my experience has been that this law is more of a programmatic model for compliance. So it's less of a prescriptive list, it's less of a checkbox approach, and more of a way to put that onus of decision-making onto the organization. Now, on the one hand, that allows this law to be flexible because it can apply to companies like Facebook, companies like IT Governance, or even small businesses that are just starting a website. But it also means it's a little bit more complicated to figure out how to comply, right? Now, I don't want to spend too much time on this webinar talking about GDPR compliance because we've hammered that home to no end, and there's certainly a lot of resources already available. But just as a reminder, again, especially for maybe the American folks on the call here, this law applies to you not just if you are established or doing business in the EU, but if you are offering goods or services to data subjects in the European Union, if you're monitoring their behavior, essentially if you're processing their personal data, you have to start to protect that data, right? And in a way, in line with European law. So another little nuance of the GDPR that folks often forget here in the States is that if you are subject to the GDPR, but you don't necessarily have a physical presence over in Europe, you do need to establish an EU representative. Now, for the most part, this is often akin to a service of process agent, right? It's the idea that you have somebody locally available on the ground that can handle and respond to questions or inquiries on behalf of your business. You see here on the slide that these people are not responsible for GDPR compliance. So this is not necessarily the person you stick with the privacy officer designation, right? They're really meant to serve as that local point of contact. But the other benefit of having this EU representative is having boots on the ground to help you understand your legal obligations in various countries or regions within the EU. So we'll talk about that a bit later because we've seen the fallout from the Schrems II case, and different countries are prescribing different approaches and requirements to how organizations should comply with them. So let's start to talk about options for data transfer. Under the routine transfer bucket, right, the idea that we're going to be transferring data quite regularly, quite often, there's a variety of options that were provided to us under the GDPR. On the one hand, we could rely on an adequacy decision from the European Commission. Essentially, that's a saying that the receiving country has laws that are similar enough to Europe that, in effect, privacy rights will essentially be the same. Now, the list of countries that have received an adequacy decision is quite small right now. It's growing as countries continue to apply. Countries like Japan and New Zealand have recently gone through the process, and I understand South Korea is going through it. But as it stands right now, the United States has not been deemed adequate. And that language, this idea of adequacy decision, will become more important here in just a second. But the other options that we were given under the GDPR, we see were the privacy shield, now invalidated by the Schrems II ruling. We've also got the idea of standard contract clauses or binding corporate rules. Essentially, the idea is that you've got a formal legal document that is applying these rights and obligations and privileges to the two entities specifically. And so from a national jurisprudence level, maybe the laws in the receiving country are a bit different, but the receiving company is held to the same European standard by virtue of contracts they've signed or binding corporate rules they've agreed to within the same corporate entity. And that's the key difference between those two. Binding corporate rules can really only apply to one organization, whereas standard contract clauses are more effective for transfers between third parties. Now, on the right side of the slide here, we've also got this concept of occasional transfers. And I like to call this out for the crafty lawyers that are on the call here. Some of you may have reviewed the GDPR and found Article 49. And it gives you almost an opt-out to say, well, yes, we know we've got to transfer.
Oh, we lost Preston again, so I'll pick that one up quickly. So a lot of people have understood it to mean that you can ask for consent, or you can use Article 49 to say that actually unable to necessary routine transfers, that you can use an Article 49 derogation instead. And I'm just picking up Preston, you froze again. I'll hand it over back again. But the challenge with this is it's very clear that Article 49 can only be used to add transfers. So anything that is a routine, normal part of your processing cannot be done on the basis of an Article 49 derogation. This is for unusual things that you couldn't foresee or predict only. So really, for anything that is part of standard business processing, you need a routine transfer basis. And Article 49 is there for things that are unexpected, where you couldn't be expected for these other things in place for that weird and wonderful transfer. Preston, back to you.
Thank you, Camilla. I appreciate it. So when we talk about these transfers, right, the key thing for us to understand in context of Schrems is the idea of this adequacy decision, right? And like I had just said, the concept fundamentally is that the European Commission would try to decide whether the receiving country, right, the country that's importing data, are their laws similar in effect such that data that is received by that country will be protected in the same way as it would be protected in the EU. And you see here on the slide some of the criteria for that decision should certainly make sense. We want to make sure we're sending data to countries that have legal systems set up so that people can honor and affect their rights in court. Countries that respect human rights and fundamental freedoms that will essentially honor privacy rights. And also, importantly, countries that have relevant laws and regulations that deal with public security, defense, national security, and criminal law, and thus talk about processing of data in those contexts with a respect to the privacy rights that are iterated under the GDPR. Now, like I also said, our options under Articles 46 and 47 are standard contract clauses and binding corporate rules, right? So we've got standard contract clauses that have been adopted by the EU Commission. And again, I stress that language, they are standard contract clauses. They are available online from the EU Commission website. They are meant to be included in full. And so while there is some flexibility for people to go above and beyond what is required in the standard contract clauses, you cannot edit or revise those to essentially lower your obligation. Now, a key caveat under these standard contract clauses, because this will become an important topic to understand, is that these contract clauses are actually dated from 2010 or earlier. So they may not necessarily consider the full scope or remit of GDPR, and they certainly aren't necessarily perfectly suited for use after the Schrems II ruling. Now, the other option here is these binding corporate rules. And like I said, essentially the same kind of a concept, right? It's the idea that you are applying legal parameters to a corporate body. The difference between standard contract clauses and binding corporate rules, though, is really, in effect, binding corporate rules can only apply to one organization. So they only cover transfers within a corporate group, right? Between subsidiaries and the corporate entity. Does not work if you've got to transfer data to an outside party. Say, for example, if your servers are stored on AWS or Azure. If you are using Google Analytics or Facebook Connect to manage marketing efforts, right? That would not fall under binding corporate rules. Presumably, you'd have to sign a contract with those people. And what you see here, most importantly, and again, this point going to be stressed increasingly after this court case, transfers cannot occur if people cannot comply with those rules, right? Simply signing a contract and walking away is not an appropriate way to do business. And ultimately, I think that's part of the reason that Facebook found itself in trouble back in 2016 with Cambridge Analytica. Companies are under an affirmative obligation to conduct a bit of due diligence and to really lift up the lid, poke around and say, can the receiving entity actually comply with these standard contract clauses? Can they actually comply with the binding corporate rules, or are they just signing it because that's the way it is, right? And again, that's what I want to stress is there are these standard contract clauses that have been floating around. They're often in place in agreements. Many of you on the call likely have already signed these, even if you're not aware. Go back and read the obligations you've agreed to, right? They are in line with old existing data privacy laws. They may not be adequate for this new change brought upon by Schrems. Now, the last option, as Camilla was just talking about, is Article 49 derogations. And the only thing I think I can really add to her points is, again, that these are really only meant for ad hoc transfers. This is not meant to be a mechanism for routine and regular transfers. It's truly meant to be sort of a one-off situation for those weird scenarios where you can't really find a path on GDPR compliance, but it may not matter because you're only doing it one time, maybe just one time or twice. Certainly not regularly, certainly not often in the case of storing data or having metrics and analytics available. In fact, I recently read a court case that suggested even the transfer of data within a company back to employees and staff in the US would not fall under this, because that's a very regular and systemic transfer, right? It's a company, it's day-to-day processes. And so these derogations sometimes are looked at as kind of an out option, a way to get around these requirements. But again, I hammer the idea that this is really only meant for ad hoc transfers and is not going to be considered appropriate for the regular and systematic transfer of data. So let's level set and backtrack just a tiny bit, right? Earlier, we had talked about the history of these rulings and the Schrems I ruling that dealt with safe harbor. You see here that these graphics I've taken from a Business Insider article all the way back in 2015. And I included this because, guys, it's been 5 years and we are still dealing with the same fundamental issue, right? And so you see back in 2015, privacy evangelists like Camilla and myself were already talking about the concept of, hey, is data transferred to the US subject to adequate protection under the safe harbor, right? And the idea is that data transfers can only occur if there is adequate protection, right? And that's what that safe harbor decision really did, is it basically said, well, yes, we know the United States won't have adequate protections, but if companies are willing to sign up to safe harbor and follow this program, they will have adequate protection, and so data can be transferred between them. But the issue, as you can see here, helpfully illustrated by these emojis, is that even if data goes to these companies that have signed up to the safe harbor agreement, wink, wink, nod, nod, social media platforms, that data still may be available to US intelligence agencies, right? And that ultimately is the issue. That was the issue back then. That's still the issue today. And so as a result of that access by the NSA, FBI, CIA, and others, that ultimately means that data transfers under the safe harbor framework were not providing an adequate level of. So as a result, safe harbor was invalidated. Now, this same logic, these same graphics can almost exactly be applied to the situation we're in today. All you'd really have to do is replace safe harbor with privacy shield, right? The idea was that companies in the United States could sign up to this privacy shield program that was monitored and administered by the FTC, and they could follow all of these rules and requirements. They could write a privacy policy that was subject to FTC review, and in that way, they would offer adequate protection. Data could be transferred to privacy shield companies. Again, recently, we've seen privacy shield invalidated, the same fundamental issue we've seen on this slide. And so as a result, there is no longer adequate protection. So a minor review of our timeline, right? Again, this started as early as 2000. It's amazing to think now we're 20 years into this topic. These principles were developed already back at the start of the millennium. We saw the development of safe harbor, but we've over time continued to see these privacy frameworks Safe Harbor, Privacy Shield, or whatever the new version may be, they continue to be invalidated by the same fundamental problem over and over and over again. It's this concern with U.S. intelligence agency access. Now, what's increasingly important for I think everyone on this call to understand is the context of this issue, right? Because we can say, okay, well, yes, this has gone on for 20 years and the law keeps changing and the lawyers keep advising me, and isn't that nice for them? But what you have to understand is the growing fork in the road that's starting to develop. And before I pass over to Camilla to perhaps comment, I want to call out this executive order you see on the right-hand side of the slide in 2017. So again, right, you saw on a couple slides ago, as early as 2004, perhaps even as early as 2002, there were already issues and concerns being expressed with the Safe Harbor framework because of supposed or suspected access by U.S. intelligence agencies, right? That really came to light in 2013 with the revelations of Edward Snowden. But in 2017, and over the course of the past couple of years, we've seen a growing divergence on this topic. So Executive Order 13768 was actually an executive order dealing with immigration issues here in the United States. It was really aimed at this idea of sanctuary cities. But buried deep in the text of that executive order from the Trump administration, there was this language in Section 14. Agencies shall, to the extent consistent with applicable law, ensure that their privacy policies exclude persons who are not U.S. citizens or lawful personal residents. So in the text of an executive order from the administration of the U.S. government, they explicitly said that non-U.S. citizens will not receive privacy protections under U.S. law. Basically what they said is we got two groups of people here in the United States. We've got American citizens and all of their data, and then we got everybody else. And if you're not an American citizen, we can do whatever we want with your data. If you don't like it, too bad for you. That was effectively what the executive order said. Now, again, it was mostly aimed at a different topic, but this language was buried deep in there. And to me, that was a signal to these European regulators, which said that, hey, we've continued over the past 20, 15 years, we've continued to express issues with the way that the United States handles personal information. And now they are effectively thumbing their nose at us, saying that you will not receive privacy protections. In turn, 3 years later, we were met with this decision we're here to talk about today. So I don't know, Camilla, if you thought that was an accurate depiction or if you had anything to kind of add to that. To me, that very much stuck out as a line in the sand that has led us to perhaps the point where we are today.
I think that's exactly right. I think that's exactly right. It is a clash of civilizations, really. Two different approaches to privacy and two different sets of priorities. And getting a way past is not going to be a matter of just coming up with a replacement for Privacy Shield. We're going to need more than that. And in the interim, it means that you've got things to do in your organizations.
Exactly. Thank you, Camilla. And so again, right, just a bit of a review. At first, we had the Safe Harbor Agreement, but eventually that got invalidated and replaced with Privacy Shield. That was a couple of years ago, and we find ourselves in the same position that we were back then. Privacy Shield has now been invalidated for fundamentally the same reasons, right? This concept, and the court actually specifically called out another executive order. They also called out Section 702 of the FISA Act. They essentially said that Europeans do not have an adequate level of privacy protection when their data is in the United States. They have a lack of rights. There's no way for them to honor and enforce these privacy laws. And we've actually seen that even if a company signs up to Privacy Shield, they still sometimes often flagrantly violate those principles, right? And we saw that with Facebook. They actually received a multi-billion-dollar fine from the FTC for just that type of activity. So what does this ultimately mean for companies, right? This idea of Schrems I and Schrems II, the invalidation of Safe Harbor and Privacy Shield, what does it mean for us at the end of the day? Well, in three basic terms, it means that we don't know what's going to happen. There's a lot of legal uncertainty at the time as these two government bodies at the EU and US levels try to decide a path forward. In the interim period, that means that we may see some people draw the line and say, you know what, data can no longer be transferred. We've actually started to see that from court cases we'll talk about here in just a second. And then, of course, for all of us business professionals that don't have the luxury of sitting in Washington waiting for legislators to get their act together and come up and come to a solution, we got to continue doing business. So we are still in this process of adapting these standard contract terms to try to meet this legal requirement outlined by the court, and basically trying to build up that level of protection at an organizational level through contractual terms. So what does this mean for companies going forward? Well, the first thing, and I think, Camilla, I'd really like to defer to you on this slide, is anyone going to enforce the ruling, right? I often know in dealing with clients here on this side of the pond, that is usually the first question out of their mouth. If I violate this law, either accidentally or perhaps even on purpose, what are they going to do about it? Camilla, I don't know if you have any thoughts.
It's a good question. It's a tough one to enforce as well, because so much processing is bound up with US organizations that it looks like a really difficult problem that people may shy away from. What I would say is, at the moment, there is quite a lot of movement about this. And we are seeing, we've got the European Data Protection Board, which is the board that coordinates all of the data protection authorities across the EU. We're seeing that proactively putting guidance together and looking at what it can do with the SCCs to publish new ones that help address some of this. So we're waiting for that at the moment. At the same time, we have court cases and complaints going through. So Matt Schrems is not letting this drop, right? We've seen how long he has been chasing this, how long he has been gnawing at this bone. He is not going to let this go. And his immediate reaction was to file 101 complaints. And those complaints are specifically related to Facebook Connect and Google Analytics. So he's taking on big companies again via small companies. Same methodology that he did with the two cases that got us here in the first place. And he is saying that it is not lawful to continue processing data, and he is pushing the data protection regulators to make sure that they are enforcing this ruling. So he also has another complaint in saying that nation states are not providing enough resources to the regulators for them to do their job, including this job, which is hard and expensive. And the reason why the Irish Data Protection Commissioner has already told Facebook to stop transferring data to the US is partly because Max Schrems has been pushing them to enforce the ruling that came through in Schrems II. So he is not letting this drop. The data protection authorities cannot brush this under the carpet, and CJEU has been very, very clear that it is going to take nation state levels of change to do something other than expecting organisations to change. And then as you look at the other data protection authorities in different parts of the EU, you are seeing motion already on this. So you're looking at two of the German states. Germany has a much more fragmented system of data protection regulation than other countries. Two of them have already said, you're going to have to do something. Berlin has said that anybody in their scope needs to relocate the data. Baden-Württemberg has issued detailed guidance setting out exactly what changes they expect organisations to make. The Netherlands is out saying organisations should not be doing this. Finland has set up an investigation into Privacy Shield practices. It goes on. Pretty nearly all of the data protection authorities are doing something. Quite a lot of them at the moment are contemplating, waiting for the European Data Protection Board guidance to come out, looking for that, I can't think of the word, coordination, there we go, so that the EU takes an action, because the EU together can do more than any one data protection authority can do on its own. So is someone going to enforce this ruling? Yes, they are. It is coming through the data protection authorities, it is coming through the courts. It's not just Schrems now, we've got other privacy organisations that are chasing this ruling down too, and other rulings. So yes, I think you can expect that there will be enforcement. And what we've seen in the past as well is that these things have begun with influence of the very large organisations forcing change on everybody else. So looking at cookies as an example, you're seeing browser companies changing the way that they are prepared to allow cookies to work and the circumstances in which they will allow the cookies to work, because that forces change on smaller organisations. So I think we're going to see some of that as well. So we have 3 prongs: supply chain, data protection authority and the courts, all showing that, as far as I can see, this is not a ruling that's going to go away. This is change that's going to have to be made, and there will be problems if you don't get on with it.
Amazing. Thank you, Camilla. And to your point just now, right, hey, the implications for businesses, both in the EU and US, is the very real threat of legal action. As Camilla just stated, Max Schrems immediately filed 101 complaints against organizations that are transferring data. And the more recent information from Schrems' organization, somewhat cheekily titled NOYB, or None of Your Business, they sent a survey out to 33 companies asking how they would approach personal data transfers. And a lot of companies are actually admitting that they don't know what they're going to do, right? And you see that these responses are from fairly large organizations, some of which have been called into the spotlight over the course of this pandemic, to help people move to a remote work or virtual workspace. It's arguable that about 60% of the companies that replied to that survey essentially indicated that they are unsure of what to do, and they're probably just going to keep transferring data to the US in the absence of a more workable solution. And so again, I don't mean that to say that you can hide within the cover, but it's a reality that this is an issue for organizations from an actual business perspective. How are you going to work around it? Keep in mind that there is a target on your back, whether directly from organizations like Schrems' NOYB, directly from your customers, suppliers, and business partners in the EU, or perhaps indirectly through your partners and suppliers and vendors, those larger organizations that have to deal with this as a matter of course, right? So let's talk about, with some of the time we have remaining, what are the alternatives, right? So we know there's a problem. How are we going to go around and solve it? Well, I think the first thing you need to understand, although Camilla, feel free to jump in, is you've got to understand where the data is and where it's going, right? So certainly if you have not done it, one of the things you should consider immediately under GDPR compliance efforts is your Article 30 records of processing, right? At a lot of organizations, the data ecosystem, as I call it, is a large and complex spider web, because data is collected from so many different places. It is shared internally with so many people, and in turn, it gets stored in so many disparate systems, some of which organizations forget they even pay for anymore. So you've got data that's going all over the world, all over in different regions for different purposes, internal and external uses. You've got to sit down and kind of pull these threads apart and straighten this out to draw a clear map of where your data is coming from, where it's going, and in turn, how it's going to get there. Absolutely.
And that's really tough. And one of the things that's particularly tough with this is if you are the data controller, so you'll be an EU organisation that's responsible for the decisions about how data is processed, then you are responsible for what every processing entity does as well. So understanding whether you count as a data controller, count as a data processor, who is responsible for this, and do they understand everything that they're responsible for, that's actually quite a big task. Because when you start looking at it, you send your data to one organisation, that organisation's using software, the software might be in the cloud, they might be using sub-processors. All of that is still within your frame of reference as the data controller. And for some organisations, they will have put these records of processing together in time for GDPR to come in 2018. They may not be up to date. They may not be sure whether they're correct. Now's a really great time to go back to that and go, do we really understand what our relationship is with the data, where this data is going, and what our choices are in respect of each of those data flows? So for every transfer that you're doing, you need to understand what your choices are and what your problems are. And this kind of data flow map is a really good start for that, but it's not small.
No, usually not that small or that simple either. And so once you go through that effort, Camilla, maybe you can kind of talk to us about some of these privacy enhancing technologies, but like you were just saying, we've got to kind of figure out what's going where in order to determine what to do with it.
Exactly. So if you have been transferring data on the basis of Privacy Shield until now, you're going to have to do something else because you can't use that anymore. So your first question is, do I know what I'm processing on the basis of Privacy Shield? Do I know whether I could use SCCs, an adequacy decision, or BCRs instead? For your routine processes. For your ad hoc processes, you've got those derogations, but you can ignore them for your core and critical processes, for the things that you do routinely in your organisation. So the first of all is, do you have another choice? Do you have another option? There are requirements for using those other options. Do you know what they are? And if the answer to that is no, and you can't come up with another basis for transferring the data, then you need to decide what that's going to look like for your organisation. And that's when we start to get to this slide, because obviously you had a processing objective that was causing you to do the data transfer in the first place. So now your question is, how can I still meet my data processing objective without transferring the data? Or what am I going to have to do to put those safeguards in place that allow me to switch from the basis of Privacy Shield to one of the other bases? What do I need to do? And broadly speaking, the three things that you can see there in that funnel are the choices that you've got. So privacy enhancing technologies are data science options that you can use that mean that you can send information about the data rather than the data itself. So they allow you to store the data in the EU and then give access to information about it to your EU recipient. So they don't get the data in the first place. And if it's not personal data, it's out of the scope and you don't need to worry about it. But you do need to make sure that you understand, if you're going to do that, how can you provide information that still allows you to meet your processing objective? So there's a bunch of different things that could mean. That could mean providing management reporting with the information that your US data recipient is looking for, rather than the data, so that they can work that out for themselves. It could mean creating a database that can be interrogated from the US, where you can find answers to questions, but not in a way that's providing you with personal data. And it can also mean providing something that looks very similar to the data, but isn't actually personal data, but has the same characteristics. Now, that sounds quite complicated, but what I mean there is doing things like scrambling the data up in ways that mean that when you process the data, then you're still coming to the same answers that you would have done had you not scrambled the data. But because you scrambled the data, you did enough to it to protect it so it wasn't personal data anymore. So those are some of the choices you've got with privacy enhancing technologies. The other thing you can do is completely anonymize the data. That's really tough, but anonymous data is not covered by the rules in GDPR. So if it's totally anonymous, it's outside the scope of GDPR and you don't need to worry about it. But anonymous is a hard standard to meet. So anonymous data means you cannot re-identify the individual from it. It's not just a question of taking my name off. You also have to make sure that the combination of data points you've got can't be tracked back to me. So that can be quite difficult. There are particular rules, there's a lot of statistics that needs to go around these kinds of things as well. But if you can do it, takes it out of scope. And if you can meet your processing objective from anonymized data, that can work for you. And then lastly, you have encryption. And encryption allows you to do two different things. First of all, it can be a safeguard that allows you to cope with the data transfer itself. So it means that when the data moves from the EU to the US, you are protecting it while it moves and preventing it from having the state surveillance that is the problem in the first place. So if you can encrypt it in an uncracked way, that can be enough. That means that you can get the data to the US, and then you're just looking at can that data now be safeguarded enough by the company that is receiving it, which basically means, is this company not in scope of FISA 702, not in scope of EO 12333? And if you can do that and the data can go to a safe company, then it can be safeguarded once it's there, and you just need to protect it while it's moving. The other thing you can do is, if you need to store the data in the US and you don't need the US data recipient to be able to use the data, you may be able to do that and encrypt it while it's there, and that might also help as a safeguard. Because again, if it's encrypted and it's to a strong standard, that can be enough to prevent state surveillance. So those are the things that you're trying to work through. So I would talk about a data utility assessment being part of this. So trying to work out, what are the data objectives that you're trying to achieve by doing this data transfer? And having decided whether it's actually going to be lawful for you to continue the transfer or not, what options you've got, and what choices are left to you, and what's going to be the best thing for you to choose, for you to make sure you're achieving your processing objectives. Which can be, as I say, it can be a data science thing, it can be a technical measure, or it can be simply a question of removing it out of scope of the law so you no longer have the problem. Preston?
Awesome. Thank you, Camilla. And so I think that that's a nice dovetail into the practical steps that organizations can start to take now, right? We've already understood from this legal ruling what the fundamental issue is, right? And like we've just kind of tried to demonstrate over the course of these previous slides, we've got arguably 15 to 20 years of case law that gives us an indication of where things are going. And so my advice would be, don't sit and wait for a new privacy framework. Start taking steps today to assess your risk, right? Very much in line with the GDPR's approach to legal regulation, but start to assess your risk on these data transfers in line with what Camilla just said, and then look at options to either effectuate that transfer in a compliant way, or perhaps more easily, at least in theory, consider why the data even needs to be transferred in the first place, right? If there's actually no value being created by this data transfer, and if there's not a real justifiable, compelling business need, it's arguable that the data doesn't need to be transferred at all. And that goes back to some of those options that Camilla talked about. Consider some privacy enhancing technologies, or consider transferring information about the data instead of the data itself. Those are sort of ways that you can reduce the scope of this issue and thereby reduce your risk. So to that end, right, like we've sort of been saying, start with that Article 30 record of processing. Start with your data map, and then review from there to see what sorts of data transfers and data flows need to be subject to a deeper level of review. And then you can decide and determine, do those flows and transfers need to occur for business reasons? If so, what is our legal basis that we are relying on? Can we document it and meet the standard that has been iterated by the Schrems II, and frankly, the Schrems I rulings? Now, for organizations outside the EU, you kind of need to do the same thing, but from the other side of the fence, right? You need to understand, where is your data coming from, because that may determine that the laws and requirements you have to deal with. But perhaps also more importantly, especially if you're not an EU-based organization, consider the concerns and the questions coming from your clients, customers, and suppliers, right? Because they are very much on the ground dealing with these laws. And so even though those of us in the United States may think of this as a problem that's far away, it's still something that our business partners have to deal with. And so from that business perspective, you also need to prepare your response contextually, right? Do you want to be the type of business that works with your customers on finding reasonable solutions to continue doing business while still honoring and respecting their rights and laws? Or are you going to be the kind of business that takes the opposite approach and goes through more of a balkanization to say, look, this is the way you do business in the United States, take it or leave it? There's pros and cons to each approach, but I think ultimately, as an organization, you have to kind of decide what you are going to do here, what type of response are you going to take, and in turn, what type of organization will you be? Again, considering the history of these laws and the likely future prospective path that we are walking along. So to that end, you also need to understand the actual business impact. Consider the idea that data transfer may stop at a moment's notice, or that certain functionality and tools may stop working. Because although you may not feel like you need to comply with these laws, certainly Microsoft, Google, Amazon, and others are going to be dealing with them, and that may impact where your server locations are stored, right, and other data transfer issues that you have to deal with when you deal with large service providers who may have more of a legal risk than you as the actual user. So in terms of next steps, right, concrete guidance, a couple of things you can do to get ahead of the curve. Of course, as always, there's no shortage of information that we've got available to help guide you through this. And we are currently in the process of releasing new information, new sorts of white papers and green papers on this topic to help educate and inform our customer base. But I think first step is twofold. Number one, if you haven't done it already, go ahead and map your data flows. I actually push that to number one because that's already a GDPR requirement. So if you've already got to deal with the GDPR and you don't have Article 30 records of processing, it may be advisable that you hang up right now and go start working on that today. Assuming you've already got the data flows, you can start to understand where your gaps are and review those for more detail. But Camilla, I don't know if you had any other kind of more practical, detailed advice that we maybe haven't already hit on, because I know I've talked about the data flows a little bit, and certainly a gap analysis. This is always a good idea on a compliance journey.
Absolutely. I think if you have been using Privacy Shield up until this point, a gap analysis, understanding what the differences of the requirements between Privacy Shield and the basis that you're likely to be moving to would be really useful as well. And I think it's also helpful to understand whether the technical and organisational measures that you've got in place are still okay, considering what this decision was. So are your encryption standards good enough? Is everything encrypted the way that you think it is? Those kinds of things, and making sure that you understand the choices that are going to be available to you as well. So for each of the different kinds of software, for each of the kinds of companies that you work with who are part of your data supply chain, making sure that you understand what they're doing, what they understand, and actually, you know, are they complying with your expectations of them? Because that's going to be part of your ability to comply with your clients' expectations of you.
Awesome. Thank you. And of course, as you can imagine, right, IT Governance and DQM are both here to help, not only in terms of the questions that you're going to have to answer, right, but our data transfer service is going to hopefully help you get ready out of the gate with prepared responses to this topic. And so Camilla, I'll maybe pass it back to you in case you want to talk about that data transfer assessment service in more detail.
Sure. So what we can do for you is we can help you understand whether you do understand where your data is flowing at the moment, what gaps you may have, and what your options are for you. So on this webinar, we can only talk in quite general terms, but we can help you come up with an action plan that helps you prioritise which are going to be the most critical things for you to look at. So where the heck do you even start? We can help you understand where your big gaps are, what your choices are that are going to be available for you. And we can put that together for you into quite a concise report that helps you understand what it is that you need to work through. So rather than just this general discussion and the general guidance that's there, something much more specific about the competencies in your organisation, the things that you're able to do, the kinds of data flow that you've got, and the kinds of challenges that are specific to the things that you're trying to do, and what that means in terms of practical actions. That's what we can offer to you from this transfer assessment, which for all of that is pretty quick. It takes us about a week for an ordinary organisation to go through and do all of the analysis for you and then come up with the action plan. And then obviously from there, if you need any extra help with working through the action plan, we can help you with that too.
And of course, to that end, right, we've got a variety of other GDPR tools and services that can help maintain or even get you to achieve compliance in the outset. Certainly, I personally have done no shortage of GDPR gap analysis. And in line with Camilla's comments, part of that effort is not just going through and pointing out where all the gaps are. It's also about educating people on where these gaps come from, why they exist, and what key work areas they can identify and prioritize in order to resolve those gaps, not just today, but also ideally to build a foundation for compliance in the future, right? As we've discussed on this call now a couple of times, this legal issue has been lingering for now almost 20 years. And so it is not a radical new surprise, although we are left with some creative solutions in how to meet the requirements of the Schrems II ruling. We also do kind of have a sense of where things are going, again, based on this legislative history and the history of these court cases. And so whether it is about getting compliant today or preparing and building for a future state of compliance, there are steps you can start taking to understand where you are, benchmark against industry competitors and others in your service sector, and then try to build a path towards compliance, right? Whether, like I said, it's just starting from scratch or you're trying to mature up the maturity scale in order to really adapt and evolve to these laws, because for those Americans on the call, we are about to start dealing with this here, right? The California Consumer Privacy Act has come into effect. There are more privacy laws on the ballot in states this November. So certainly data privacy and cybersecurity as a topic will continue to be one of increasing importance, not just from an international business perspective, but also for just simply transferring data within the US between states, because every state is going to have different laws and different levels of protection. And so this same issue may come to us sooner than we think.
Mm-hmm.
Now with that, I know we're at the top of the hour, perhaps slightly over, but I'd like to save time as always for any questions. And of course, I'm happy to hang over. If you have to drop for your next Zoom call, don't be afraid. We'll certainly make attempts to send out these webinar materials after the call. But I want to save this time for any questions that have come in on the chat feature. So I'm going to break this out and see kind of what we've got.
So while you're having a quick look at that, the other thing that I wanted to mention is we are writing a green paper on this at the moment. It will be ready in the next couple of weeks, and that's available to anybody who's been on this webinar. And that will be able to go into more detail than we've managed by talking in an hour about specifically what the requirements are, what the actions are, and what your choices might be. So hopefully you'll find that useful, and that will be one of the things that we can follow this up with. So Preston, why should we start with the questions?
One of the first ones is, what about using AWS or presumably maybe some other service providers, but explicitly asking them to only store data in the EU, right? So, you know, AWS does kind of offer that, where you can choose where you want your data stored. What if you just said, hey, keep it all in Ireland? Would that help?
Yeah, so that helps, but I don't think it necessarily solves the problem, and I'll explain why. So you can choose where your data wants to be located with a lot of these cloud providers, and it's definitely a good idea if you can do that to choose the EU servers. That it's really helpful. However, it's still not completely in your control, and it can cause you a business continuity problem in the future that you need to have made sure that you factored in. So one of the things that happened in the UK at the beginning of the COVID lockdown that we had over here was all of our children got sent home to start working from home. And that meant that the cloud services that were powering our schools suddenly had an enormous amount more call on them and more demand for their services. And as a result of that, at least one of the cloud services wrote to the schools and said to them that their product for schools could no longer confirm that it was only going to store data in the EU because they needed to manage the continuity of the service. And for that reason, they were going to reserve the right to send the data to other places. And that's your problem, because under the CJEU ruling, if you have an organisation that says, I can no longer comply with the requirements that you've given me, I'm going to do something that isn't safe, that isn't compliant, you have to stop the transfer. And that's a business continuity problem. So as long as Amazon or whoever, whichever cloud provider you're using, is storing your data in the EU, then that's fine, but you have to have a plan in place for what if they stop. How are you going to know that that's happened? In the case of the organisation that I was talking about, it was on page 8 of the privacy update. Right? It wasn't like there was a really good notification. So what are you going to do to make sure that you recognise should you find yourself in that situation? And what will you do instead? What is your fallback position? And then with all of these things, your challenge is, well, if you've got a fallback position that works better, why isn't that your plan A in the first place? So this is, for me, it's a safeguard, it helps, it's a good idea, you should be doing it. But you do need to be thinking about this business continuity issue that can come to you if it fails. What happens when that safeguard goes away?
Awesome, thank you. And so we've got another question here. In fact, it looks like we've got several good ones. This question here is, do companies in the US have to share information with government agencies? And Camilla, if it's all right, I'm happy to take that one. What I would say is, if the FBI is knocking on your door with a badge and a gun, you're welcome to refuse them. Good luck with that. But to be more serious, I think that's kind of the issue with this question is, on the one hand, if the government comes to you and demands access to the information, are you really going to stand up and say no? Some companies have done that, right? Microsoft and Apple, if you remember a couple of years ago, with the debate over the shooter and the encrypted phone, some companies have the legal weight to go toe-to-toe all the way up to the Supreme Court. I would argue that most companies don't have that much money, and they certainly don't have that desire. So there's that question of, okay, if the government comes and asks, what are you going to do about it? But then also the issue is, what if they don't ask, right? I don't think it's too cynical of me to say that there is a demonstrated history of these government agencies perhaps surreptitiously intercepting the data while it's in transit. And I think that's ultimately one of the things you have to consider here is it's not just the data sitting on your servers. What about when you mail it on Outlook or Gmail, right? What about when it is on a cable that is managed and owned by Verizon? And I'm not calling out any one company in particular, but you have to remember there is the service provider that you probably deal with, and then there's also that electronic communications carrier that maybe is a service provider to your service provider, right? A couple of links down in the supply chain. Can you guarantee that everybody in the supply chain is blocking access to government agencies? Because if not, if there's one crimp in that chain, that might be a potential avenue for these regulators or for an attorney to say, look, that data is not subject to adequate protection. Because even though it was maybe protected at the company, while it was sent in transit, it was subject to interception and interference. And so Camilla, I don't know if you feel any differently, but that's kind of my thoughts is, do companies have to share?
I think
it depends on how much they want to fight.
So it comes back as well to the point that I was making earlier about you as a controller and the processes and sub-processes and their sub-processes and how that whole data supply chain works. Certainly in terms of data breaches, we are seeing quite a high proportion of personal data breaches are because of something that went wrong as a sub-processor. And from the EU's point of view, unlawful state surveillance is a personal data breach that you would be responsible for. So understanding how that works is one thing. The other thing that I was wondering about was whether the thought behind that was, are all companies in scope of FISA 702 and Executive Order 12333? And the answer to that is no. Those are specific to electronic telecommunications companies. But the chances of you not having an electronic telecommunications company somewhere in your processing are pretty slim unless you do everything by post and physically going from place to place. So more than likely there's something in your supply chain that is in scope, and you need to make sure you've got the right safeguards in place while that is happening. And at that point you are talking about things like encryption, where the provider doesn't have the key, so the data is effectively meaningless for them.
Awesome. So the next question is a pretty interesting one, and Camilla, I may toss this to you for your thoughts first. I know we were discussing this. What are the thoughts on last week's white paper issued by the US government? And for those that don't know, maybe just let me set. So in response to all of this, the FTC has said that Privacy Shield is still valid, it will still be enforced. And the US Department of Commerce recently released a white paper sort of arguing for that and basically arguing that the court case was invalid. So Camilla, I'd be kind of curious to know your thoughts, I think, on both sides of the pond here.
Yeah, it's an interesting one. I would certainly say that the white paper that's come out is it's a fairly spirited defence of the way that things are. So they make a number of points in that white paper. They make the point that what was invalidated was not today, it was the decision that was originally made in 2016 to decide that Privacy Shield was going to be okay. So one of the things that they said is since then, there are more safeguards in place for individuals, and that the US is now closer to being where the EU would want it to be. And that's kind of true. You have made some steps forward, but there are specific things that the EU would be looking for, which you clearly don't have yet. You do not have a federal privacy law. You do not have the kinds of data protection authorities that you see across the EU. So there are still gaps, although it's probably true to say that it's gone further. It also says that not all of the data that gets transferred between organisations in the EU and the US would be of any interest to state surveillance agencies in the first place, therefore it doesn't matter. That's possibly true. That is certainly something where you could conclude that in your risk assessment. But on the other hand, Max Schrems' view seems pretty clearly that the law is the law. And it's pretty difficult for most organisations to know what state surveillance is going to be interested in because they don't do that themselves. And it also says that actually the EU benefits quite a lot from the state surveillance that the US does, uses the intelligence that is gathered through FISA 702, and therefore should be grateful. And so for those reasons, we should get over ourselves, basically. It is a spirited defence. I think it makes it very clear that this administration that we've got at the moment probably isn't interested in sort of rolling over and listening to what the EU has got to say and then doing the things the EU is asking for. And so I would say, I don't know what, I don't know what administration you're going to have, whether that will change after November and whether if it changes, it would bring a different approach. But I would say that the consequence from an EU perspective of that white paper is that it would increase what I would see as the pressure on companies to do things that are going to comply with the law themselves, and to assume that certainly on the basis of that white paper, we are some way away from a political solution to this. Preston, anything from your side?
No, I think I would agree, Camilla. I think, yeah, to me, it's a retrenching of current affirmations, and it, to me, sort of indicated that it sort of, I would have expected a little bit more conciliatory of an approach. So kind of to your point, I think it will be interesting to see how this goes forward. Certainly in the midst of an election, which may be a referendum on policy here in the States, but I think that may be kind of a sign that perhaps, hey, there is a fundamental difference in privacy in the US and EU, and if that difference is really going to be entrenched, then maybe we have to start to look at other options, like one of the other questions, where we simply have the data stored elsewhere, right? I think one of the tricky things, and we've sort of seen this somewhat tangentially with this TikTok debate that's been going on in the US with the current administration, companies and governments are recognizing there's a lot of business value and national security value in data. And they are increasingly recognizing that other countries understand that. And so if data goes out to other countries may be able to leverage that business value or national security value. So I think as a global society, we've kind of got to agree, are we all going to work together here, or are we going to separate further and continue on a path that we've kind of been for years, where it's just that, hey, there's increasing differences in the legal frameworks and we cannot come to a reasonable agreement. And so as a result, there will be different rules for different internets in different parts of the world, right? And we see some of that in various parts of Asia currently, where certain websites simply just aren't available. And I fear that may become a business strategy for some American companies, is to simply say, you know what, it's not worth the effort.
It's interesting.
But I don't know.
Facebook's response to the Irish Data Protection Commissioner telling them that they had to stop sending data to the US was to say that they would stop providing services in the EU. So certainly it is possible that we could end up with this sort of fragmentation of what is currently a global economy. Is it really going to happen? The markets are too big. But it does mean that there's going to have to be some technical and some legal solutions to this, which won't be coming anytime soon. But what is coming soon is this requirement to make sure that the way that things are now is organisations' response, it's your responsibility, and it's for you to make the response to it.
Right, right. Okay, so some other easier questions here. The first one I see is, what is an SCC? And the answer to that question is, that's a standard contract clauses, right? So that's just an acronym for what those contract clauses are. And another question, sort of more logistics oriented, is, yeah, hey, asking about the PowerPoint slides, and it looks like that was answered. Yep, certainly planning to send those out. So another question here, do you think that the UK, oh, interesting one. So do you think the UK will find themselves in a similar position as the US come the end of 2020 due to Brexit and existing RIPA 2000 legislation? So great question from Rob. I think I've got some stuff to go research.
It is. It's a really good question, and it's very difficult to say at the moment. Certainly, a lot of data protection commentators think that this decision wasn't helpful for the UK getting an adequacy decision of its own. So we certainly in the UK have a lot more state surveillance than would be tolerated in any of the other countries in the EU. And there is also a question with the way that the Brexit negotiations are going about whether we're going to choose to align ourselves more strongly to the EU or more strongly towards the US, and we don't really know the answer to that at the moment. So if we get an adequacy decision, then there will be no problem with data transfers between the UK and the US, the UK and the EU. If we don't, then we will become a third country just the same as anybody else. So we'll either end up with the UK becoming a 14th country with an adequacy decision, or we will be a third country which will have exactly the same challenges that we've been talking about today for the US. And that applies, you know, for any country that doesn't have an adequacy decision and isn't in the EU.
Yes, and I think that's also interesting to consider, you know, again, from this question from Rob, don't forget that there are other countries that were implicated by Snowden's revelations. So by extension of this ruling, I would think some of those countries are no longer adequate. And in my mind, I'm just thinking, you know, Australia maybe coming to light. I'm not 100% sure, but the other countries I'm thinking about, what about countries like China and Russia, right? That also have a fundamentally different approach to things like data protection, state-sponsored surveillance, et cetera. And so again, that's kind of what influenced my response earlier is, over time, it seems like different countries are taking a different approach, partly based on culture, probably partly based on business and military reasons, but different countries are taking different approaches to the sharing and storage of information. And as people become a little bit more balkanized, I could see over time where we might find ourselves with a segmented internet that really operates differently depending on where you are in the world. And now I'm just kind of spitballing off the top of my head, but again, consider if the EU courts have problems with the way the United States conduct surveillance, certainly there are more authoritarian regimes that do the same or more, and one would think that data is no longer safe to be sent there either. So this is not strictly an EU versus US problem. It's really the EU versus countries that don't have adequate privacy laws. And so again, I think that hopefully will influence the way legislation of this topic goes going forward. And for those, again, those in the states that pay attention to this, we've seen talk continually. This year it's kind of slowed down as other social issues have come to light, but there's continual talk of a federal privacy law, and that may sort of set the balance and get us back on track on whether that will be completed or not.
Yeah, the last point that I'd like to make.
So I've got another question here. What do you think? Oh, yeah, go ahead.
So I was just going to finish off that thought by saying, we're seeing ripple effects from this as well. So the next thing that happened after the privacy shield between the EU and the US fell was there was an equivalent one between Switzerland and the US that fell as well very quickly, within a week, I think. And if any country has adequacy with the EU, one of the things that would take your adequacy away is if you were seen as a backdoor route. So any country with adequacy is probably going to have to take the same view as the EU and start doing the same thing. So it's not just a question of, if you're a US company, this is coming from the EU. It is also coming from all of the strange places with adequacy decisions. So the big players like New Zealand and Japan, but also the Faroe Islands and the Isle of Man and all of the other things that have got adequacy decisions as well. So you need to be thinking about that too while you're doing your assessment of exactly where these problems are coming from for you. Those places are going to be asking just the same questions.
So here's another kind of interesting question. What do you think about continuing to use Google Analytics after this Schrems II ruling? Is it still legal? And I will caveat this as the lawyer here. Certainly our response can't be considered legal advice. You'd want to talk to your own counsel, et cetera, yada, yada, all that good stuff. But certainly I think Camilla and I could try to talk about this. Camilla, do you want to start? What do you think about still using Google Analytics?
So Google Analytics is the subject of the 101 complaints by Max Schrems that he doesn't think is legal. So that's interesting. However, Google Analytics covers a multitude, and it may be that some of the services are more okay than others. So in the EU, you can't put Google Analytics onto somebody's computer. You can't use that without their consent. So there's already some controls over the use of Google Analytics. And also, when people talk about Google Analytics, there's a number of services that cover everything from a depersonalized, almost anonymized set of statistics tracking, all the way through to ad tech and list building from websites for retargeted marketing. They're not the same at all from an EU point of view. My gut feeling is, for a lot of organisations at the moment, the idea of just switching Google Analytics off before there's been a very specific decision that it is not okay is a really hard decision to make. But I do think you should probably be considering your use of Google Analytics and deciding which of those services are going to be causing you the bigger problems and how much value you're getting out of it as well. There are alternatives to Google Analytics, and you may want to consider whether there is a safer alternative for you to be using. It's certainly not something that's flying under the radar. It is considered to be risky.
Yeah, and I think my concern would be with Google Analytics, to your point, Camilla, it's a very confusing ecosystem, and Google, has been in trouble before with the complexity of their privacy documentation. And so I think part of the issue with Google Analytics, outside of the legal theory, is just literally sitting down and to your point, Camilla, saying, which service are we actually using? In turn, which privacy documents apply? In turn, is this still valid or not? Again, just because Google is such an encompassing tool, and the way they have structured their privacy documentation is slightly confusing. So it's not necessarily the easiest to kind of peel apart just what data is being collected by them, which data is staying with them, which goes to you, and how that transfer is affected. So I would certainly say, if you're using Google Analytics, you may go back to your agreement and review the terms of the data processing addendum, ideally there is one, and see if they've spelled out clearly just what they plan to do, because some contracts I've seen were written in such a way as to consider the abolition of Privacy Shield, so they may have already outlined a path forward, but if not, it may be something you have to dig into more deeply. The other thing I will say is, generally speaking, in my experience, Google Analytics relates to marketing. Marketing is often one of those business areas that's out there collecting a lot of data in the wild. You know, Camilla, you just raised a good point about consent. There's a lot of similar issues, right? The e-privacy regulation and this cookie consent laws that get swizzled together here, right? And so once you start talking about Google Analytics, to me, that's where I have to sit down with the marketing people and say, okay, what are we collecting? Is it mobile device IDs, STK units, right? IP addresses? Are we collecting consent for cookies? And what are we doing with all of this stuff? Because maybe it's just me, you know, it's hard to sometimes argue the business value of all of this surreptitious data collection just to share a newsletter or marketing communication.
Absolutely, absolutely, and that is a challenge. The other thing that is something sort of worth mentioning is the number of people that are using browsers that don't allow these kinds of things, that are switching them off. And the behavior of the browsers themselves, most modern browsers will not accept third-party cookies as default. And it's likely that in those policies and those default settings that these things are going to get tightened up as well. So one of the challenges that I always have with these kinds of things is whether people make assumptions about how much information that they're getting that aren't really valid or are becoming less valid over time, and how well people are understanding that. So that's a lot on Google Analytics. I do think it's potentially going to cause problems in the future.
Awesome, awesome. Well, as I review our questions, some other questions relate to slide recordings, and yes, I do hope to make those available, you know, and send those out to our attendees after the call. There's one more question that I thought I would follow up with individually because, frankly, I don't know the answer off the top of my head, so I'll throw this to Camilla in recognition that we're almost 30 minutes over. But Camilla, this question, does FATCA still apply regarding financial and banking data transfers?
Ah, FATCA, lovely. It's a tough one. So data protection legislation works alongside other existing laws. In general, what the EU says about legal basis is that something has to be the law in an EU member state or in the EU in general, and a law anywhere else doesn't apply in the EU. However, there are some reasons why data sharing can be okay between member states. Part of that is covered in the Article 49 derogations. Specifically whether FATCA is covered in it, my guess would be that bits of it will be and bits of it won't, but I can't answer the question in enough detail to specify it. It certainly means that if you are going to be sharing data for FATCA reasons, you're going to have to review your documentation, your decision making, and your thoughts about exactly what data you're transferring for that.
Okay, awesome. Thank you. Thank you very much. Well, with that, guys, I think that's kind of all the questions we've had, although certainly you're welcome to reach out to us in the future for any questions on this topic, as our contact information is included on these slide materials that will be sent out. And of course, you're also welcome to ping me, or I would assume, Camilla, they could ping you on LinkedIn or other channels as well if they've got more questions on this interesting topic.
Absolutely, please do. Always like having more people reaching out on LinkedIn, and I do quite a lot of stuff on LinkedIn.
Cool.
So.
Well, with that said, I appreciate.
Interesting.
Nice, nice, awesome. So, with that said, I want to just say thank you to all that have joined and have hung around this long. I see some of you still hanging around to answer all of these questions we've got. Certainly an interesting topic. I know there's more to come on this in the future. And to that end, stay tuned through IT Governance and DQM. Like Camilla said earlier, we're in the process of releasing a green paper on this topic, and certainly more information to come as guidance gets released, as regulatory bodies release more information. We'll be certain to distill that and pass it onwards to you. So again, this is Preston Bucati with Camilla Winlow, just saying thank you for joining this morning or this afternoon, wherever you are around the globe. Hopefully you've enjoyed this, and we hope to see you again on another one of our webinars soon.
Super. Bye-bye. Thank you.
Thanks. Bye.